Good evening. My name is Will Cheatham from the law offices of Wee, Cheatham and Howe. This evening you will be participating in the presentation of a slip and fall case where the plaintiff is claiming negligence on part of the store and the store has an affirmative action defense in that the plaintiff caused the fall and is responsible for her own injuries. I'd like to go over a little information before we begin. Regarding tort law, a business visitor is a person who is invited to enter or remain on land for a purpose directly or indirectly connected with business's dealings with an economic benefit to the possessor of the land. An invitee is a person who enters upon the land of another upon an invitation which carries with it an implied representation, assurance, or understanding that reasonable care has been met to prepare the premises and make safe for the invitee's reception. Slip and fall cases are based on the duty of care that a possessor of the land owes to the invitee. A possessor of land is subject to liability for physical harm caused to his invitee by a condition of the land, if, but not only if, he A, knows or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk or harm to such invitee, and B, should expect that they will not discover or realize that danger or will fail to protect themselves against it, and C, fail to exercise reasonable care to protect them against the danger. A proprietor is guilty of negligence only if he A, fails to use reasonable care under the circumstances to discover the foreseeable dangerous condition, and B, fails to correct the condition or to warn customers of its existence. Principles of notice versus duty. Causation and notice should be treated not as elements of the customer's case, but as an affirmative defense to the proprietor. The customer would retain the burden of proving that there was a foreign substance or object on the floor and that it was a substantial factor in causing the accident or injury. In certain circumstances, property owners can be vicariously liable for injuries caused to invitees, but that is based on solely on the relationship between the proprietor and the invitee, which would not be applicable in this case. Oregon also has comparative negligence, or referred to as comparative fault. In this case, the plaintiff's recovery can be reduced by fault even if the plaintiff's negligence exceeds the defendant's negligence. I would go further to address that the onus of burden of proof placed on the retail customer by cases such as Jones versus Jarvis, Kentucky, 1969, Wiggins versus Scruggins, Kentucky, 1969, Cumberland College versus Gaines, 1968, and you may know locally of Kroger Grocery and Baking Company versus Spillman in 1939. These are general principles. They relate only to the duty owed by a business proprietor to his customers and not to the burden of proof as to whether that duty has been violated. There are several stipulated facts which were mutually agreed upon before this court appearance. Number one, the plaintiff was shopping at the grocery depot on March 23, 2007. Number two, the plaintiff's cousin, Mike Daniels, purchased them both soda drinks from the deli at 105 on March 23, 2007. Plaintiff was discovered unconscious by her cousin, Mike Daniels. The incident occurred sometime between 1:50 and 2:05 p.m. Tammy Harris, the produce department manager, signed off having checked the floor at 1:20 p.m. on March 23, 2007. Deborah Billings, the deli clerk, also signed off checking the floor at 1:40 p.m. The plaintiff had partially smashed bananas on her foot, and there was a smashed banana on the floor, as well as some very light brown juice on the floor. The plaintiff had a bunch of 3 bananas in her cart. Grocery Depot had an overripe bananas on sale for 50% off of the regular price. And Grocery Depot's policy is to check the floor every 20 minutes for any problems. With these facts being said, thank you for participating in our presentation tonight. Please take care and pay attention to the facts and the details when deciding the case of Allison Peterson versus Grocery Depot Incorporated. Thank you.